Afternoon, Luke.
Good afternoon, Judge. Good afternoon.
Which case are you here on?
Yes, Judge. So,
Here
yeah,
on Janelle?
yeah, I think Casey has a conflict.
I do.
So
Thank you, Luke. Thanks for
Oh,
jumping
she
in.
does. I thought Ross was going to be here.
he had a schedule conflict. So
Okay.
going deep in the roster, Judge.
All right. Well, all right. Good thing. Sometimes the number 5 hitter has a higher RBI average than the number 4 hitter.
Well, wait to see.
Good afternoon, Ms. Strong.
Good afternoon, Your Honor.
Good afternoon, Ms. Washington. Can you hear me?
Yes.
This is Judge Middleton. I'm here on behalf of Judge Pattison. Also here is Casey Strong from the Public Defender Group, and she's here. You got arrested on a bench warrant in this case. That's file number 231559SM. You were charged way back in June of 2023 with kicking somebody's window out, about $700 worth of damage.
They
And
didn't have a
looking through-
receipt.
Well, just a moment, Ms.
Okay.
Washington. We'll talk about the facts. Let the judge speak about
But
the.
if we're talking about the facts, I didn't get charged in June then.
All
Ms.
right, well, your
Washington, don't
lawyer,
say anything right now.
Oh
We'll
my
talk.
God, okay.
your lawyer is Paul Gibson.
Okay, that makes
And-
sense.
Ms. Strong, you don't know this, but Ms. Washington does. She and I are related. She's about my first cousin twice removed. Her grandfather was my first cousin. And so I try not to handle her cases, but sometimes I'm compelled to. But this was a Judge Pattison case, and it's filled with Ms. Washington failing to appear when she was supposed to. There were, I think, 3 separate bench warrants. Then she failed to appear for sentencing, and Judge
No.
Pattison set the bond at $5,000 cash or surety. I'll let you- What they said is, oh no, then you were placed on probation, and there was a
15 days time
probation.
served and 20 days time served.
Ms. Washington, we'll talk
Oh, yes,
about.
you got
He keeps
20
saying that
days.
when I was stating the facts, why can't I say the truth? And then he said I had to go to probation. He said, come check in with the probation officer until you can see if they bring me a receipt. I talked to them. They don't have a receipt. They talk to the courts. So if you want the truth, then don't Miss Washington. I'm not listening to you then. I'll stay in jail forever if I gotta
I
listen
want
to
to
you
hear
lie.
everything you have to say, but not when we're on the record. Give us a moment, okay?
All right.
We'll talk
At
about it.
any rate, you are correct, Ms. Washington. It was a probation violation bench warrant. And you're right, there were issues about how much the window was worth. They claimed it was worth $759. Judge Pattison ordered something less than that. He's not here today. And how did you get arrested last night?
I didn't. I got arrested this morning. I was literally walking down the street.
Okay, in Sturgis?
Yeah.
I'm gonna set PV arraignment for 10:30 on November 19th. Mr. Gibson is set to be there that morning. And I'll let Judge Pattison deal with this. He wasn't very happy about this, why he set the bond at $5,000 cash or surety.
You said my bond?
Yes.
How? If I got time served and the people told me that I don't have to pay anything because they don't have a receipt or evidence that I did anything.
Well, he put you on probation, and
No,
then
he
you
did not.
never complied with any of the terms of probation.
Okay, so
Well, you
I got a $5,000 bond because I'm ready to go back and lay down. I'm not in the mood for this. I've been in court like 15 times for something I didn't fucking do, and I already got 16 days time served. I'm tired of doing this. I'm tired. I just want to go to fucking sleep. Leave me alone.
All right, you got 20 days, credit 20 days, and then there's this probation issue. So you go back and
No,
take
I
a
literally
nap.
got 16 days
Judge
time served and
Pattison will
20
see
days
you.
time served. I didn't get put on probation because I don't have anything that I have to pay.
Yes, you do. I think you have a disagreement with what Judge Pattison ordered.
No,
So
I
anyway,
don't. I literally talked to people.
take
They
a
don't have
nap.
any evidence that I broke the fucking window. They said there is no receipt. I went there 3 different times and had them fax the paper and everything, and this is so irritating. Can I go back to sleep? If I got a 5,000 baht, I'm not getting out then, so can I go back to sleep?
Yes, yes, you can.
Man, it makes no fucking sense. Every fucking, open the door! Goddamn! Man. I'm passing me that. This is so fucking stupid. How do I get time served and then I have to open the door?
I think you can see why Judge Patterson set the bond at $5,000. I had to study the file. She did get 20 days, credit 20 days, and he put her on a probation. And then she failed to comply with any of the terms, failed to report, failed to pay fines and costs, failed to abstain from the use of alcohol or drugs, failed to participate in treatment, failed to maintain full-time work. She had a probation violation hearing set for October 21st, and she failed to appear. See how she's doing when he sees her on Tuesday.
Yeah, I'll send Paul an email and give him a heads up.
No sense diving into contempt. Just get her on her way. Good morning.
Way to go. Started off on mute. How about that? Hey, everybody. Welcome to American Courts. That lady was kind of goofy and crazy. She is kind of the highlight of my week. I can only imagine what family reunions are like for Judge Middleton if she shows up. So thank you, Nancy, for gifting a membership. That's always fun to see. Congratulations, Durall. Welcome to the crowd. Welcome to the crowd, Durall. It was Nancy. Nancy, she's floating around there somewhere. She gifted a membership. Thank you so much. Leanness is gone. She has left us. She is tired of the United States and she has gone home. She has gone home. Idaho's driving home. Nan's here. Rivette's here. We can always count on those folks. Thank you so much for last night. Last night was a fun video. We had a good conversations there last night. We're going to jump on to. Do I do this before you're coming? Yes, absolutely. Absolutely, KK, that works. We're going to jump into, we got Judge O'Donnell, we got another Judge Middleton, we got Judge Simpson, and we got some Judge Fleischer. So we got a good night tonight. Let's jump over to Judge O'Donnell.
Judge, today is Jeff's birthday. Turns 43 today. Not the best way to celebrate his birthday. He's taking responsibility for his conduct. As the court knows, Jeff is 43, he has 2 daughters, a 6-year-old daughter and an older daughter who's attending school. You have a letter from her and you have a letter from a number of other people that know Jeff. And the thing about these letters is they talk about what kind of guy he is, very helpful, very compassionate guy, there if you need him, do anything for you. And they point out some of the circumstances where he has done things for people. In owning this bar, Kate's Bar, that he's had for a number of years, it really provides his income. And he's had a number of employees there that he's actually took care of during the pandemic. He did a lot of things, went out of his way to make sure people, had what they needed to get through the pandemic, had jobs or had money or food and things like that. And again, I point that out, and that's in some of the letters you have there to get an idea what kind of guy he is. He got kind of caught up owning this bar where people come and they drink alcohol and do other things, and some people some of his patrons were doing drugs, predominantly cocaine. And he got involved in making cocaine available to certain people. And doesn't deny that as a big mistake. Just kind of got caught up doing it and continued to do it, and realizes something he should have never done and how it's going to destroy his life and his daughter's life and his little 5-year-old daughter who is in kindergarten, and how he's got to deal with telling her where he's going to be. He's had a couple of semesters in college. He's a low-risk scorer. He's got a father who is a police officer, a brother who is a police officer presently. So he has some good examples in his family as to what should be going on. And this has been a real turnaround for him in his life. He, and on behalf of him and the state, we've entered into an agreement which we know doesn't bind the court, but we've entered into a joint agreement for a recommendation of 18 months, and he realizes this court can give him whatever the court wants to do on these things. I guess what I can say about Jeff is I've not known Jeff for a long time, but the period of time I've known him here, he's been very remorseful about his conduct, very concerned about his family, concerned about other people and his friends, how it's going to affect them. He is forfeiting $50,000 in addition to some monies that they did find at the bar. The $50,000 represents kind of his interest in the bar. He had to give up the bar, and so he no longer has that for a source of income. By giving up the bar, he had to say goodbye to some of the people that worked at the bar, some of his friends. So it's going to be a total change of life for him. When he gets out of prison, which he will someday, he has plans to go into real estate. He has dabbled in real estate in the past, but it's going to be quite a change for him. So he's prepared for whatever the court gives him today. I believe he's got a very low risk score. I think we've looked at some of the criteria under the Ohio Revised Code for sentencing. He is remorseful. I'll tell the court how remorseful he is. He indicated that in his pre-sentence report. It's nothing that I think had any dangerous, it didn't injure anybody, but he does realize the risks of engaging in any sort of drug trafficking or drug sales. The amounts that he did actually sell to people were F5 amounts. There were drugs at the facility, at the bar. They were kept in a shared room, and he's taking credit for it, but I think other people had access to it also. So we're going to ask the court to follow the joint recommendation if the court will. I know that Jeff would like to approach or talk to the court also.
Mr. Myers, what do you want to tell me before I impose sentence?
I just want to apologize to everybody that I let down, the burden I put on family and friends that are here, that are not here, to my daughters who need me and are not going to have me. And I never want this to happen again. I'm never going to allow it to happen again. I just apologize to everybody.
There were, I think, 6 different buys here, right?
I thought there were, I thought we pled to 4 different buys, Judge.
Yeah. Pled to 4, there were 6 that were done
Right.
before the search warrant was executed. So how long have you been selling drugs out of the bar?
It was those isolated times. I mean, a few times, and it was mainly just helping
Well,
out a friend.
But it was a confidential informant that set
Right.
you up, right?
Right. That
So
was.
how did that person know to go to you to buy drugs?
It was my brother's boss, and I was just helping out a friend. I was helping out my brother's boss, essentially.
Your brother's boss.
Yeah.
Who's that?
The guy, I forgot his, what was his name? The informant's name, I forgot his name. It's, what was his name? Do
Well,
you have the information?
Yeah, I don't remember.
Kurt, it was Kurt.
A call is placed to you to buy drugs from you, and 6 times they place this call, 6 times they buy drugs from you. And those were the only 6 times you ever did this.
Essentially, they were all isolated incidences. I was just helping out my brother's foreman, yes. He'd reach out to my brother and ask if there's someone that could help him out. And I knew that there was someone at the bar that I could also grab it from to help him out. So I told him, yes, I would help him. And being my brother's good friend, I thought it would just be a quick situation. Like I said, they're very isolated situations. It was
Well, who are the other people in the bar that you were helping out, kind of going as a go-between?
just customers that are at the bar that are no longer been around. They don't come around anymore. They weren't really even friends per se. They were just people that were there that I knew that had the capabilities of doing it.
How long had you been letting Horn and Bush operate out of there?
I don't. They haven't been around in 2 years.
Well, this all happened 2 years ago,
right.
right?
That's what I mean. They haven't been
How
around.
long had they been
How long were they?
hanging around?
They were
with
probably
you?
hanging around there for a couple years prior to that.
Okay.
No, I don't know what they were exactly doing. I mean, whatever they were doing, I had no knowledge of, and I didn't really.
You didn't know that Bush was a pretty prolific drug dealer?
I've heard things, but I really didn't affiliate with him that much. To me, he was just a customer. I just.
See, your
No.
whole story in here doesn't ring as being true.
I mean, I've heard of what he's done, and I know about him, but I didn't affiliate.
Talking about what you have said in this thing. It seems rather unbelievable that a CI places a call to you 6 times, and 6 times you sell them drugs. Then the place is raided, and there's a bunch of cocaine in there, some weapons that you really had no knowledge of, right?
They were in the shared room, yes.
Okay, shared with who?
The shared room was with every other business in the whole building.
Right.
Multiple businesses.
So that wasn't really yours then?
No, I mean, it was partly mine. It was all the other businesses so the whole building is broken down into 4 separate businesses, and all of those businesses shared that room.
Okay. Which other businesses?
It would have been a yoga studio.
Which you had frequent access to, right?
Well, no, not frequent access. It was connected to the shared room. It was on the other side of the shared room.
So anybody that wanted to come in the bar that rented one of these other facilities could get into your bar through the shared room?
Just a yoga studio. Then it was also connected to the trophy shop. Technically, I guess the trophy shop would have been able to have access. And then there was a 4th business that didn't have access to the bar through the shared room.
There was one or two occasions where the CI called you to arrange a sale.
Yes.
And either Horn or Bush were there to complete the sale. Why was that?
Because they were the ones that had it. So I might not have been there. I didn't really want to do it because it really wasn't, like I said, something that I did. It was just isolated incidences. What I thought was just helping out somebody, which was stupid. So if they were there, it was probably them that ended up handling it because I was not there. I was trying not to even do it. I don't want to be any part of it. But being my brother's foreman, I just thought, okay, I'm just helping out my brother real quick. Not, I mean, stupid, but.
Why wouldn't you have just referred him to Bush or to Horn? Say, I don't know nothing about that stuff. Here's these 2 guys, you can get it from them. Why not do that?
I mean, because I don't think they would have trusted it at first. I wasn't thinking that's what I should have. I mean, I should have done that. I shouldn't have done any of it, to be honest. You know what I mean? But in that scenario, yes, I should have. Instead of me being the middleman, all I doing was playing middleman.
Yeah. Well, see, this just isn't believable.
What do you mean?
What I mean is I don't believe you.
Well, that's what it was. I was playing middleman to them guys and to my brother's foreman. And I could have just directly introduced them to each other, but I don't think they wanted to meet somebody new, and I don't think that's how they wanted to do
Well,
it.
if Bush and or Horn were dealing drugs out of this bar and your customers knew that, why didn't they just go directly to those guys?
Well, these guys didn't know each other. This is my brother's foreman lives.
I'm not talking about the foreman. One of the things that you said is that customers that would go to your bar were interested in getting drugs, and and Bush and Horn were frequently there, right? Dealing drugs?
They were there, yes.
Okay. So you were acting as a go-between. Why were you acting as a go-between with customers?
I would act as a go-between because they didn't know. Not everyone knew each other. Like, they didn't know every single customer, as far as regular just bar customers.
See, this Bush and Horn
Right.
have worked a bunch of these bars all over the place. Okay, so
Okay.
you knew that,
Yeah,
right?
I-
If your customers were buying from them, they knew that. So why are you just being this nice guy go-between to satisfy your customers?
well, I wasn't to everybody. I was only doing it to certain people. I mean, I was only helping out a couple people. I was never involved with whatever they did. I was never involved with all their day-to-day transactions with customers.
Why do you say you're sticking your nose in the business of Bush and Horn with other customers, with your customers in the bar? Why are you sticking your nose in that if you don't know nothing about nothing?
Just trying to help out my brother's friend. That's what I mean.
Well, your brother's friend, you're saying, is a CI, right?
Right.
I'm not talking about the CI. I'm talking about you making the claim you're a between customers in your bar, customers, not the CI, and Horn and Bush.
But I only did that. It was only a couple times. I was just small, isolated few incidences. I wasn't an everyday occurrence. I wasn't a continuous thing. That never went on like that.
All right, so you weren't keeping cocaine in the yoga studio either?
No.
Okay.
No, they all had access to that room.
Who's they?
Bush, Horn, all
How
the,
did, what unit did Bush and Horn rent in that?
they didn't rent
Which
any,
of the
but they
four
were friends
units?
with the yoga studio.
Okay.
They were friends with the owner. They were also friends with the other owner
What other owner?
of the yoga studio.
Who's the other owner?
I forgot her name. It was, it's written down probably somewhere too. What was her name? I don't know if her name's written down there. Lola. A lady named Lola. So she was the owner of the business next to me who also had access to the shared room. So they were all friends with her. One of them might have been dating her. So there was multiple ways to get into that shared room. One of them was
Okay.
also through the
Did you
yoga.
know there was cocaine in that shared room?
No, I did not.
You didn't.
No.
Did you know there was cocaine in the yoga studio?
No, I did not.
You didn't go over to the yoga studio on one of these occasions and grab some cocaine and bring it back and sell it?
I went over there, but I didn't know anything was in there. I just went over there what I grabbed.
What do you mean you grabbed?
What I grabbed for the CI.
Okay, so you knew there was cocaine there.
Well, what I had on me. Like I didn't know if anything stored there. I don't know anything about marijuana there, weapons. No, I didn't know anything that was stored over there that these guys had over there.
Okay, you went over to the yoga studio, got the cocaine, came back to the bar and sold the cocaine.
No, I met him in the yoga studio.
Okay.
He was in the yoga studio.
Why did you meet him in the yoga studio?
It was just quieter, not as,
Why not in the kitchen? Usually we're doing this stuff in the kitchen, right?
Yeah, there was occasions where that's where it was.
So
but
why did you do it in the yoga studio?
I think it's because there was less people around at that time. It was just quieter. It was just where I went. I don't want to be around people.
What else you want to tell me?
That I wish I had never done any of it.
Well, you did.
I know. I mean, nothing I could do about it. I mean, I did what I did. I wish I didn't. I wish I didn't help out anybody. I wish I never even hung out with those guys. I wish I didn't meet those guys. I wish they never came out to my bar.
Well, if that's true, then you would have kicked their asses out of the bar when you knew they were selling cocaine, wouldn't you? It's your bar.
Yeah.
So why didn't you kick them out?
I kind of overtook it. It got to a point where there was so many of them, and it was, I don't know how to explain it, but it was almost it was hard to control that many group of people. There was a lot of them up there every single day. It was hard to.
Selling drugs?
I mean, not just that. I mean, just being in general, just drinking, hanging out, playing rap music all day, doing whatever they're doing, living that kind of life.
You knew they were selling drugs, right?
I mean, I knew that's what they did. I didn't watch. I knew that's.
See, you can't keep.
Well, yeah. I mean, I knew.
When you start lying, you can't
Not
keep straight
lying.
the lies because you told me that you were kind of a go-between for
Yes,
Bush and Horn and customers, right?
Yes.
So you knew they were dealing.
Yes, I knew they're
So
dealing.
why did you let them deal out of your bar?
I didn't let them deal out my bar.
You knew they were dealing out of your bar, right?
To an extent, yes.
To an extent. To what extent?
I knew they're doing a little bit here and there when I would ask them to grab it for the people.
Okay, so why did you let them do that? That's my point. It's your bar. Why did you let them do that?
I don't know. I guess just bad judgment call. I mean,
Okay? And if you couldn't do anything to control it, why didn't you call the cops? and say, I got guys dealing drugs out of my bar. I like my bar. I like being the bar owner, and these guys are ruining it. Get them out of here. Why didn't you do that?
I don't know.
Your father's a retired cop. Your brother's a cop. You knew you could do that, right?
I just want to deal with the consequences of them finding out. If they found out I called the cops on them, then I have to deal with, I don't know what the consequences.
You're the one that put, according to you, you're the one that put yourself in that position by letting them do that.
Yes.
Now, I don't believe that. I believe you were right in the thick of things, selling. Okay, I don't believe you only did it 6 times and you did it to help buddies out. I don't believe that. It's just that it's not a story that's believable.
Okay. It's the truth, I'm telling you.
All right.
It was never my thing. It was always their thing. It wasn't my thing.
All right, anything else you want to say?
No.
Mr. Geigerich?
Thank you, Your Honor. I just would acknowledge that Mr. Perez handed me the remaining part of the forfeiture this morning. And we'd ask that the court impose an 18-month agreed sentence in order forfeiture of the contraband, the weapons, and the currency of all the instrumentality was seized at the bar. Thank you.
So is there additional currency that was seized that you're talking about, or is that part of
Yes,
what?
there was a total at the bar, I do believe, of $11,000. It's total of $52,741.26 being forfeited, Your Honor.
There was $11,020.26.
Yeah.
Taken from the bar. And
From the storage area,
Pardon?
right?
From the safe.
from the safe. And the money was all bar money, but, yeah, that was, money was seized.
But it's a total of $52,000.
Correct. So the concept is, Judge, that of the $52,741.26, they seized $22,741.26. The remaining money is all part of the $50,000 that we're giving to the Lake County Narcotics Agency in lieu of them taking the bar. So the 27,
Taking the bar, how? How are they taking the bar?
well, I think their concept was the bar could be a, criminal premises that they would be able to seize because criminal activity was going on there.
They recovered $2,741.26 from the defendant and $8,479 from the office. So it was a total of $11,220 were seized in the search warrant, Your Honor.
Okay.
But he's forfeiting $52,741.26.
So who owns the bar?
What's that, Your Honor?
Who owns the
His
bar?
mother owns the bar, but the bar is being sold, and so the bar, as indicated, was going to be sold to somebody else. For a number of reasons, they backed out of the deal, which caused him an issue as far as getting all the money that had offered. It's now being sold to somebody else at a lower down payment, and it's also a requirement of the Liquor Control Commission that the liquor license be transferred out of his possession.
All right, I reviewed the pre-sentence report and the letters that were provided by Mr. Perez. I've considered all the provisions in 29, 29, 11, 12, and 13. The thing about you, Mr. Myers, is that it's apparent to me that you were pretty extensively involved in this case. And you pled guilty to these charges. And Mr. Perez had indicated you're taking responsibility for this, and you're not taking responsibility for it. You're saying that you were just a middleman, you did this on 6 occasions, and it was Horn and Bush and whoever else. I don't believe you. Okay? I don't think you're taking responsibility. I think you're trying to minimize what your role was.
No,
in
I
this.
was-
You're
sorry.
trying to minimize your role in this thing, okay? And so you're not taking responsibility for it. Just pleading guilty doesn't mean you're automatically taking responsibility for it. So I'm not going to adopt the joint recommendation of council. I'm going to sentence you to 24 months in prison, and you pay the court costs, and the items subject to forfeiture are forfeited. When you get out, you might be on post-release control for up to 2 years under the parole authority. If they place you on post-release control, they'll put conditions on you. If you violate their conditions, they could return you to prison for up to 9 months for each violation, up to 1/2 of my sentence. If your violation is a new felony, you could get an additional consecutive prison sentence for the violation, the maximum of which would be the greater of 12 months or the time left under post-release control. Is there anything else, Mr. Geigerich?
Yeah, how are you allocating that, Your Honor?
24 months on the 3 and 12 months on the rest, all concurrent.
Thank you. He has a fine though too, Your Honor, mandatory fine.
Of how much?
It's 10,000, so it's a minimum 5, but he can waive it if.
Judge, we'd ask the court to consider the amount of money that we forfeited in lieu of the fine.
Well, I don't know that I can do that because it's a mandatory fine. So why don't you file a affidavit of indigency?
I will.
And then I won't sign the entry until that affidavit gets filed. So
All right.
I'll impose a $5,000 mandatory fine, but it would be waived upon the filing of an affidavit of indigency.
Okay, thank you.
All right, we're adjourned.
So the guy didn't really know that they were selling drugs, but he was the one handling the drugs. He was the one giving the drugs out, but he was just doing it to be nice to the drug dealers and be a nice guy to the customers. So he obviously wasn't doing it because he wanted to make a quick buck. He obviously didn't know anything about it. And so, but hey, Big and Raiders, thank you for coming out. Thank you for jumping over. We really appreciate it. It's always great to see him raid over. He had some wild ones on tonight. I snuck in there with some young girls threatening to stab somebody in the street, and so it seemed like a typical Biggin night. Had some just craziness going on. I didn't see what state it was, but I'm assuming it was Florida with people threatening to stab each other like that. Looks like we got Kathy and Victoria. We got Julie, Drunk Smurf, KK. Looks like we got everybody over here. Again, everybody, Linus is gone. She's gone. She's back in international waters, so she's out of our world. We're going to let's go to Judge Middleton. He had a good one on, I think it was yesterday. I think this one was. Let's see what we got there.
All right, you are here as a tenant in a landlord-tenant proceeding.
Mhm.
This is a house which has had some issues over the years. Once again, Dr. Krimis is asking to take possession of a premises back. Attorney Michael Boersma is here on behalf of the plaintiff. Let me explain to you, ladies, what your rights are as tenants in a landlord-tenant proceeding. This is filed as a termination of tenancy. As far as I can tell, there is no lease, but they're asking you to move. All right, as I said, I've had some cases in the past regarding this same property. Each time it was young women that were renting the property. Here we are. You're there. He wants you to leave. Ms. Hirschberger and Ms. Wilson, what's your position?
So we've lived there for over 8 years. I've always made sure that my rent is paid on time. I take care of my yard and I'm a good neighbor. Now they switched things over to be, instead of giving your rent in person, you mail it. So I mail it, it gets lost in the mail. So during that time of trying to find my rent money, because like I said, I've never been late. I've always paid my rent on time. I started getting threatening calls from them. I told them that I was trying to locate the money because of course this is my money as well, that I need to figure out where it's at. They started to shut my electric off. They shut my gas off. I told them that I wanted to talk about this in court. They shut my gas off, they shut my electric off, they broke into my house, left all my doors unlocked. They started following me. And then now also too, there's an issue with the electric. So when I first moved in there over 8 years ago, they didn't tell me that I would be paying for my neighbor's water too. So this
Well,
entire,
this is a recurring thing. This house was the residence of the fire department, and two houses are on the same well.
right,
So this is like deja vu all over again.
Yeah.
I've heard this issue before. Mr. Boersma, I'm amazed that we didn't get a lease this time. Did you ever have a lease?
yes,
So, Your
Um,
Honor, there is a
yes.
lease. I was not the one who filed the present motion to evict. So my client actually was the one that filed,
Yes.
and I, gather from what the court is saying that he failed to or inadvertently failed to include a lease, and then there's a lease amendment as well, from earlier this year.
All right, well, is there a lease in effect right now?
Yes,
they have a lease, but they want me to sign a paper saying that if any of the furnace, the soft heater, thing breaks, that I have to pay it. Otherwise, I get kicked out in 3 days. So there's that they wanted me to sign.
All right, well, there are other issues. There's something called the Landlord-tenant Relationship Act, and something sometimes referred to as the lockout law. It's unlawful for them to turn off your electricity or your gas.
Yeah, it's all
They could be sanctioned with a financial sanction. Also, if you have a lease that's in effect, you have a right to pay the rent.
Mhm.
And they file this as a termination of tenancy. Now, if there is no lease, they don't have to have a reason. They can just say, we'd like you to move.
Right.
If you do have a lease that's in effect, they have to have a reason. Either you haven't paid your rent, in which case you have a chance to pay the rent. Or they have to say the reason why they want you to move. They haven't done that. And the problem is he didn't bring Mr. Boersma into the matter soon enough.
I would, Your Honor, I just need a little bit more time. If I could get 30 days to move. I've got some people helping me because I'm in a wheelchair. And so I've got some people helping me. It's just with being in and out of the hospital. That's why I'm still not out. But I do want to move because I don't feel safe there. Like I said, they are calling between 1 a.m. and 4 a.m. yelling at me to get out.
And they can't do that either.
Well,
Now, at one time, he had a property manager that was very aggressive.
Yeah.
And that is it that person, or is it?
August's son, August, and then also, yes, Stan. Stan's following me. I asked August.
Oh, Stan is still involved in this?
Yeah.
Oh, boy.
And so, Your Honor, like I said, like I've always paid my rent on time. I've kept my yard nice. It's just they're trying to get me to pay for my neighbor's water. And then I find out that he's growing pot. And so no wonder my electric bill's been so high. And I didn't get a heads up when I first moved in. They didn't tell me this until 3 months after I moved in. And it's so hard to try to find a new place, which I ended up finding a new place. I just need a little bit more time to get the rest of my things out. But yeah, it's bad.
Frankly, Mr. Boersma, I wish they'd stop renting this house. His property manager has caused a lot of aggravation to the tenants over the years. And if she's true that someone shut off their electricity and shut off their gas and and went into the house without the permission, there are significant issues regarding that. Tell me about your gas and electricity being shut off.
So I told them that I wanted to go to court because I have no idea, Your Honor, how much my electric is because, like I said, it's running off of my neighbor too. I called the electric company. They said there's no way to tell. And so I told August that I want to settle this in court. I want to talk to, Your Honor, so that way we could get this figured out because me trying to handle it's not working. They just say, pay the water bill, otherwise you get kicked out. So I found a new place, like I said, and
Well, back up. What I asked you is,
oh yeah,
when did they shut off your electricity?
they shut that off a month ago.
What do you mean? It just was turned off?
Called them, they called the company and shut it off, both of them. They also told me they were going to lock me out before court, that they were going to change the key so I couldn't get in there before court. And then, like I said, Stan's following me.
Is Miss Hirschberger there also? Okay, is that your daughter?
Yes, also my caregiver.
So you indicate that you have found a place to move to?
Yes.
How soon can you be in there?
So I just need 30 days to be able to get the rest of my things out of the old place.
Mr. Boersma, if she's accurate, there are some clear violations of the lockout law for which the plaintiffs could be ordered to pay her money. She's the third tenant or fourth tenant to complain about the property manager following them or making their lives uncomfortable. But she indicates that she would move voluntarily. Perhaps we could resolve this by a consent judgment where you give her until the 15th of December, 16th of December to vacate, and she would agree to move voluntarily. Is that acceptable to you, Ms. Wilson?
Yes. Yes, Your Honor.
Is that acceptable to your client, Mr. Boersma?
Yes, Your Honor.
My client indicates yes, Your Honor.
All right. Now, you're consenting to an agreement whereby you'll move by December 16th. If you don't move, you'd be subject to being evicted. This is going to be entered as what's known as a consent judgment. I don't have one here in front of me, but Mr. Boardman will send me one. If you misunderstood what we just did or felt like you were pressured into doing this, you have 3 business days to ask to set this aside. But what I'm going to do is enter an order that says you have consented to moving by December 16th. If you don't move by December 16th, you're subject to being evicted. When you move, you need to turn in your keys and give your forwarding address within 4 days of your moving. Mr. Boersma, this is going to be a continuing issue regarding this well. And Dr. Krimis, in the future, before you do anything, your son does anything, or Stan does anything, talk to Mr. Boersma first. You could have yourself in some significant difficulties by turning off your tenant's electricity or gas, or calling them in the middle of the night. So you're to stop, not to have any contact with them pending this move out. Or you could end up paying her a substantial amount of money. So she's going to agree to move voluntarily. When you file a complaint, you're supposed to file a copy of the lease. I don't think you even have the right to the relief you're asking for. I think she has the right to pay her rent, but she wants to get out of this situation, and I don't blame her. So she's going to move by December 16th. She'll turn in the keys and give the forwarding address. Mr. Boersma, I think you've got our email address.
I believe I do, where I can call the clerk's office. And get
All right.
that, so.
Very good. Well, if you'd email me a judgment, I'll sign it. All right. Ms. Wilson, best of luck.
Thank you, Your Honor.
And I will send you a copy of that judgment when I get it and sign it.
All right, I appreciate it.
Thank you.
You know, she was feeling it was an uphill battle until the judge started saying that he's dealt with that apartment complex time and time and time again. It sounds like that property manager needs to get swapped out. You know, if the owner can't, you know, if you got a bad property manager, there's nothing you're going to do to change that judge's mind. So you might as well let that company go, get you another manager. Tell them that's just how it goes. I'm so excited to see Kathy here. She's at work, but she's hanging out with us. So I feel like we're gifted here. So, yeah, KK, about 7:00 at night, that dog goes to sleep. She's just a wimp. She'll actually whine, and by 9 or 10 o'clock, she'll just whine until one of us goes to bed, bed with her. Yep, Gina, they're going to try to forward her bill. I never heard them say that they got the power turned back on, so I don't know. I don't know how she's got power. I don't know anything about that there. So, but yeah, I couldn't be a landlord because I'd be a horrible landlord. I couldn't kick out a single woman, but the day they don't pay the rent, everybody would be kicked out. So it'd be a bad deal if I was a landlord. Wouldn't do good there. Let's go, Judge Simpson. He had a lively one. He tends to find them too. So let's see what we got.
Your name, sir?
Timothy Kelly.
I have two motions up. I have your motion to set aside the default.
Put the picture of my daughter here. She's an occupant. She wanted to be here to say something, but she was in school.
Okay.
Thank you.
That picture is not going to happen that way. You're not going to sit up there and display things to the court that way.
Okay, I asked first. I'm sorry. I've mentioned her a lot, so I just wanted you to see her.
All right, let's deal with your motion first, Mr. Kemp.
Okay. How come I could? Your Honor, did you get the evidence package, the exhibit evidence? I asked the girls when I walked in. Girls, I mean the nice ladies up front.
I have these picture exhibits. I don't know if Ms. Dornbush has them or not, but
No.
I have them.
Okay, you do have them?
Your Honor, I do not have them, just so the court is aware.
All right. I thought they were both sent because I have a double thing where you could send group, and I sent them. At any rate.
Okay. All right.
Your Honor, I just, with due process, the most important thing is being heard, and I haven't been able to be heard yet and state my case and defending myself with all these accusations. And, that's why I know I missed the trial, but there's all kinds of reasons for it. I've met all the demands of the court. If you remember, I was before you for 4 or 5 months in a row dealing with the rent, and we made decisions, and I lived up to the demands and so on and so forth. So I did you read the motion where I gave you?
I have read everything that comes in this.
All right. I didn't know. I'm just, I want to have a trial.
Sir, I gave you that opportunity to have a trial on October 30th, and you failed to appear.
I know, but fails to appear sometimes happens. Can I read something to you, Your Honor? This is all diversion programs and sent down by the Attorney General to try and help tenant-landlord disputes. That a judge could take a proactive role in the hearing by ensuring that both parties know.
What are you reading from?
It's recommendations from, we never even got a chance to talk or settle. I mean, we had a last settlement conference, but we didn't talk about anything. And before that, the attorney and the landlord, the property manager kept me from talking to him. We couldn't even try and settle. And throughout the whole thing, all the legal stuff that I read is that you try and work it out before the eviction case. And also I have I have, this is for sure a retaliatory eviction, and you wouldn't even let me speak on it the one time I brought it up. Because,
Sir, you know what?
what? If you give me a trial, Your Honor, did you read the character references my neighbor sent you?
Do not,
The Mitchell.
do not come here
What?
at this hour questioning me
I'm not.
about what you think I haven't read. I have just told you that I read everything in the file.
I apologize.
Do not come here before me, because all of these people have been sitting here, they've been here, and tell me ever that I won't give somebody an opportunity to be heard. Do not insult this court that way. Do not insult me that way. Now, if you want to start your argument again, you may, but you will not sit here and impugn the character of this court or of me with regard to listening to tenants and landlords regarding these proceedings. And you will not attempt to try to school me with some literature as to how to handle a case. I have been doing, you know what?
What?
I'm gonna pass this case and because I want to make sure that I'm listening to you. And I don't think these other people that are sitting in here should have to wait through your shenanigans. So have a seat.
I'm confused, Your Honor. Please. I didn't say it was you. I said due process. That's all I said.
Have a seat.
I wasn't saying anything.
Have a seat and keep your mouth closed. You throw something down again, we're going to have a problem. Will you throw something down again, we're going to have a problem.
Sorry.
I'll retry this. Court recalls the case of River Ridge versus Timothy Kelly. This is your motion to set aside the default judgment. There are two parts to the setting aside of a default judgment before you start going on. The first part is that you have to have good cause for failure to appear. State every reason for your good cause for failure to appear for the trial.
Oh, you want me to state it now?
I asked the question.
Okay, I'm sorry. I thought you were making a statement. Well, as I iterated in the motion, that one, I don't have transportation. It's very hard to get it. I don't have the money for an Uber or a taxi or any of that. If you recall, I told you, for one of the hearings, I rode my bike 30 miles round trip. So it's not that I wasn't trying to get here. And I also, right from the beginning, everything I've told you has been the truth. I mean, in the beginning of we had trouble with the rent. I told you that I was also going through litigation with the friend of the court. And as a father, that's a very hard thing to figure out and such. So that's one of the reasons was my daughter called me that night. She had an emergency and I had to take care of it. And she was with me the next day, the trial day. And
we received no notification or phone call from you indicating that there was some delay or some reason why you couldn't be here that day. Is there a reason why you didn't call the court?
Yes, and I'll tell you, that week I had dropped my phone and it broke, and I had no way to call anybody. I didn't have any way to get any of my trial stuff out. I couldn't access anything. I didn't have the money to buy another phone. So for 4 days, 5 days there, I was in purgatory, so to speak, without being able to communicate, without being able to get anything off the phone pertaining to the trial or this case. And that's the truth.
You mean you couldn't have found a place to call from?
Pardon me?
You couldn't have found a place to call the court from?
Yes, well, I was in the middle of this. Look at my child I can't, I don't want to put it on record yet because has to do with some serious things going on with her safety wise. So, and I didn't know, it's very hard to, I don't want to, can I ask you a question about the trial? I mean, I don't want you to think I'm questioning your judgment, but I'm confused about why it was set on to the bench when I demanded a jury trial way back.
We have already gone through this. You failed to comply with the escrow order. Plaintiff was entitled to a trial as to the issue of possession, an immediate trial. I set it out a few days. We have been through this. I'm not relitigating everything, nor answering all of the questions that I've answered for you in the past, Mr. Kelly. I'm just not doing it.
I don't recall us talking about whether it was going to be a bench or a jury. Honest, Your Honor. And I've
Your Honor,
met,
I can state the exact date that this was addressed because I specifically emailed the court to clarify if the jury was waived and was able to verify. So I can remind the court the exact date that conversation happened.
I thought at that time that it was
I'm not going back over this.
Your Honor, if you would listen to, if I could cross-examine witnesses and bring my witnesses in, you'd see a different light on this, I swear. I haven't been able to present anything. You don't, I mean, may I ask you another question that I don't get? I'm not questioning you, but I wasn't there and I don't understand how it came to the trespass and the witnesses that I can't go around them. What was said that you think I'm a danger to the community?
It wasn't an issue of you necessarily being a danger to the community. They were trespassing you after the writ would issue. It's as simple as that.
Okay, well, I mean, those were a couple on the list were friends. I mean, I get along with Kevin, and so I didn't understand why I was out, but it was a good reason. I want you to know the facts of the case. That's all.
The second thing is that you have to state to the court a meritorious defense. Please state your meritorious defenses, Mr. Kelly.
Well, can you help me out with the meaning of that more?
No.
No? Okay. Well, I know have a right to counsel, but all the resources are used up. I have tried for since this case began to get some help from the state and all the resources that are listed, and nobody, they're all filled up. I think it's hard to even express because I'm afraid I'll offend you. And
sir, do not try to blame me.
I'm not blaming you
this
at all.
You just need to say what you're going to say.
Okay, well,
I don't think that there's anybody that comes before this court that would at all indicate I don't listen. I may not agree with you, but I will always listen. So don't try to put it, poor me.
No.
Somehow this judge won't listen to me.
I'm not.
Say what you have to say, and then I will make my decision.
Well, I had all kinds of things written down. I started to read it and you said, don't read that to me. Well, I don't know how to present. Can we go over the evidence? May we do that? I marked all the.
Your Honor, I would object. I've not seen this evidence that Mr. Kelly is referring to. It certainly wasn't attached to the motion that I received. I don't know when it was filed with the court, but I've not seen this evidence to be able to comment, to be able to prepare any sort of response to it.
It pertains to my oral argument already on the record, Your Honor.
I'm going to sustain her objection. You can't come here with new things expecting for the opposing side to respond to them.
Well, I was going to fill out.
It doesn't work that way.
Okay. I was going to fill out an amendment to the motion, but I've been up all week, all night trying to just get the proper paperwork into you and do it all right. It's not easy being 95% of us tenants don't have lawyers. We're pro se. So, I don't know where to get any help as far as the legal, but she has been able to bring the list of the original offenses. She's added on to that throughout the trial, the plaintiff has. I mean, now my dogs, first it was just 4 items. And she's brought up my dog, so she's added on without. So I'm just confused about the way to present evidence, I guess. I mean, she brought up my daughter missing a day of school. Where did that come from? I mean, all
I
of
didn't
those have
mention
been.
his daughter at all, Your Honor. I'm sorry. When
It's
did
in
I
the
mention his daughter?
it's in the transcripts. I can't pull it up right now, but it's there because it bothered me. Honestly. I mean, I don't know how to present to you. Why don't I get to present the retaliation defense? You haven't listened to what
Sir,
happened there.
I need meritorious defenses you have to this claim.
You can't tell me what, may I look the word up in my phone?
If you can do it quickly, you can go ahead and do it quickly.
Never mind. Okay.
No, go ahead and look it up.
I don't
And-
know.
Your
Well-
Honor, while Mr. Kelly is retrieving his phone, I just want to make the court aware that I would like an opportunity to respond to.
Oh, absolutely. As soon as we can get there.
What's the word, Your Honor?
Meritorious.
Meritorious. Could you spell it for me?
No.
Okay. See. Oh,
You filed the motion.
yeah, I probably should have paid attention to that.
Yeah.
Well, it's hard. I've been reading everything in the law. It's the only way I can do anything. And there's a lot to take in, Your Honor. The delay, suspension of an act. Oh, okay, I know. I did read that. That's kind of like what they did for COVID with the money. Do I have that right? Sorry.
I don't know what you're talking about.
Well,
I have no idea.
is it moratorium? I'm sorry. Okay. My defense is that I just want to be heard. And I didn't say that you did anything wrong to make that not happen. But with reading all the stuff in the legal that you have to read if you're pro se, I'm not an attorney, but I'm starting to at least learn some of the laws between tenant and landlord, and everything I read is the land of America is trying to the courts handed down by the Attorney General and the Supreme Court on helping the litigants, especially the tenants, because they're the ones that are come to you with no resources as far as money for an attorney or any of that. And the landlords always have the best attorneys. Like I said, 95% of us are pro se. So all I can do, and I told you an attorney called from Michigan Legal Help, but he just left a message and never got back to me. And so I have to read on these motions and read on the appeals or read on how to go about a defense. And when I present
No, come back. Okay, can't, no, I was gonna make, I think you should stay too. Go ahead.
when I'm trying to present the retaliatory eviction, there's all kinds of writings on that in the law. So it must be something that happens in court or they wouldn't have it in there, correct? I mean, I'm not a bad person. I want you to know the truth, Your Honor.
I'm not saying you're a bad person. Miss Lee, you have arisen. Is there a reason?
I'm sorry, Your Honor. I did want to corroborate Mr. Kelly's account. He did get in touch with our hotline, our housing intake line. We have been trying to give him advice over the phone, but we did not have the resources to represent him. If you would like me to sit with Mr. Kelly for a bit and try to assist him a little bit further, I'm happy to do that.
Okay. Yeah, if you're willing to do that, Ms. Dornbush, I'm sorry to hold up your evening, but I will allow it to happen because I'm probably one of the most unfair judges I've ever met, but
I didn't say-
I'm gonna try to be fair.
I,
Mr. Kelly,
can I,
step away from the podium?
may I give you a
No,
compliment,
no,
please, Your Honor?
No,
Okay,
do not give me a compliment. Do not say anything to me at this
all
time.
right.
I'm gonna handle Mr. Fink's case as Ms. Dornbush. Sooner or later, you'll be able to go home.
Okay.
She's gonna be mad at me.
I would never dare.
I tried. River Ridge versus Timothy Kelly. If Ms. Dornbush.
I am still here, Judge, yeah.
I've called the case. What are we doing?
Well, Your Honor, as far as what you asked me about the defense, I just want to make a notation at the bottom. It says, upon information relief, resident has failed to remedy the violations after being given an opportunity to cure. Thus, grounds for termination exist. I did cure all of them at the time they asked. Every time they ever asked, it was always, I always met their demand, whether I liked it or not. So I would like an opportunity to go to trial and defend this and show you that. And as far as any verbal abuse, I put in one of my letters that, or one of my motions that somewhere there's a phone call of that, because it was a three-way conversation, and I didn't know if I needed to look it up or not. But as far as the upon information belief and all those lists, please.
So everybody's talking about how long it's going to be for Miss Dornbush. This video still got 27 minutes. So a landlord case that normally don't last 10, 15 minutes, and it's been going on for 20. It's still got another 27 left. So here we go.
I deny them, and I can go one by one if you want. I'd just like the opportunity to show you and cross-examine witnesses if there are any, trying to accuse me of this. I adamantly deny most of what's on here. I mean, there was the car, we talked about it, on the grass, but that was during the settlement conference. During what I was just trying to explain to you is that's not how it was. It says parking on the lawn on or about. That car was on the lawn for about 3 months, and then she asked me to move it to the drive. We pushed it to the drive, and then it finally got towed 3 months later for expired plates, because the car wasn't running at that, but it had legal plates up until that point. So that's all I was trying to explain that one day about the car when, the final settlement conference. I wasn't disputing that at one point it was on the lawn, but it's kind of, and I don't know how that works, but I do have witnesses for most of these to dispute them. And I don't know if you have that in front of you, but doesn't that read like if the cure was given, that there wouldn't be grounds for termination, or am I reading that wrong? Because I did cure everything they've ever asked me to do as far as moving.
All right, Ms. Dornbush, your response.
Thank you.
Oh,
Your
I'm
Honor.
sorry, I don't have.
Go ahead.
I'm waiting for Mr. Kelly to get his hearing device.
Thank you.
Your Honor, at the outset, when Mr. Kelly first began speaking, he made a statement that he has complied with all demands of the court. And I want to first address that statement because that's absolutely false. Mr. Kelly has not complied with all the demands of the court because he was ordered to do several things early on and he did not do any of them timely. Most recently, he did not pay the full October rent into escrow. He did not pay November rent into escrow. He did not pay rent into escrow with the motion that he filed, even though he checked the box stating that he did. He made a statement, Your Honor, that there was no opportunity to settle this. That is also false because Mr. Kelly and I had a very lengthy conversation back in August, at which time we did attempt to settle this, but the settlement offer that I was authorized to make was not something that Mr. Kelly was satisfied with. The only settlement that Mr. Kelly wants is an agreement by my client that he can stay. And that's not something my client is going to agree to. And I made that very clear to Mr. Kelly. Your Honor, with respect to Mr. Kelly's motion and his statement that he has good cause for his failure to appear, he put many things in his motion, Your Honor. I would say the majority of them have absolutely no relevance to the issue of good cause. That is delineated in the response that I filed with the court. And Your Honor, just for Mr. Kelly's awareness, there was a glitch in our system, and the address that I mailed my response to, which it went out day before yesterday, so we probably wouldn't have been delivered by today anyway. It's not going to go to him. So with his permission, I will email him a copy of it if he wants it for his records. I'll stick it in the mail as well, because I do have his email address.
Okay, yes, well, you have the court's permission to do that, understanding what you
Yeah,
just
I don't have a problem.
Thank you, Your Honor. The specific issues that he put in that I believe have absolutely no relevance to the issue of good cause is that the court being aware of his transportation issue and his having to ride a bike to the court previously, he somehow managed to get here every time. Further, for this specific motion, or excuse me, the trial date, Your Honor, Mr. Kelly stated he had a ride lined up and he chose not to take the ride because of another reason, and we'll touch on that in a moment. But he had a ride lined up and he has a ride today, I believe. My client's here and sees that there's another resident in the community that she believes may have driven Mr. Kelly to court today. So clearly he has the ability to get transportation here. As the court noted, Mr. Kelly didn't call the court. And Mr. Kelly made a statement that his phone was broken. But Your Honor, I seem to recall, and maybe I misheard, but in this hearing, when questioned about why he didn't call the court, he said he didn't have a phone. But just a minute before that, didn't he say that his daughter called him about an emergency?
The night
So
before.
daughter was able to call him the night before. If his phone was broken for the 3 or 4 days before that, somehow he didn't have a phone the morning of court to call. But not only that, he's obviously got people in the community that are there to support him. As the court pointed out, he could have borrowed a phone from anybody. So I don't believe that Mr. Kelly has stated good cause. For the additional reasons stated in my motion, Your Honor, he stated his belief that he'd be given a break because default was a possibility, may enter. But Your Honor, Mr. Kelly's been in court before and failed to appear, and a default judgment was entered against him. And I referenced that particular case number in my response. Your Honor, he referenced his concern related to his alleged request for a jury trial, but the court has already touched on that. And Your Honor, the date, just for the record, that that particular issue was addressed was September 20th of this year. He cites an alleged case with the Michigan Civil Liberties Department, and I assume he means the Michigan Department of Civil Rights when he states that. Again, has no bearing on his good cause for appearing at the trial date. That he was finally in touch with an attorney from MI Legal Help. Again, no bearing on his good cause for failure to appear, and that he intends to file appellate pleadings. Again, no good cause for his failure to appear. Your Honor, this emergency with his daughter, I'm sympathetic to whatever's going on in his family situation, but Your Honor, Mr. Kelly has been stating various times throughout these proceedings that this alleged custody issue has interfered or detracted from his ability to meaningfully engage in this court process. And Your Honor, I personally did a search of the Circuit County Register of Actions. I don't see anything pending in that case. My understanding from what's available on that Register of Actions is that Mr. Kelly's ex-wife has sole legal custody of his daughter. And one of the police reports that we were able to obtain from the Michigan State Police, and I believe it's from sometime last year, I don't have the exact date, that there has been no change in that. They specifically referenced that his ex-wife has custody, full legal custody of his daughter, and that there's been no change to that. If there's been some change between 2023 and now, Your Honor, it's not showing on the Register of Actions, but there's nothing pending showing in that case with the Washtenaw County Circuit Court. Your Honor, with respect to this alleged meritorious defense, first off, we've already addressed at the settlement conference before Mr. Kelly was taken into custody for that bench warrant, why additional things were added and more specifically stated in our complaint for termination of tenancy. And that is because the demand that was issued, Your Honor, states reserves the right to bring this and other issues that are lease violations to proceed on the termination action. And so at that court date, Your Honor, which was approximately 3 weeks ago, Mr. Kelly had notice of what additional grounds would be relied upon by plaintiff. One of those issues was an actual admission by Mr. Kelly with a photo he provided to the court of his dog sitting outside on a tie out. Community doesn't allow that. And frankly, Your Honor, the dog was tied out again today. Mr. Kelly nowhere in sight. My client is signed into Zoom right here, and she could tell the court that, again, the dog was tied out. Mr. Kelly was not out there with him. Minor violation of the rules, Your Honor, yes, but it's just a continuation of Mr. Kelly believing the rules don't apply to him, Your Honor. And that's unfortunately been how this process has gone throughout. Every time the court has ordered Mr. Kelly to do something and he didn't follow through, there's just been some reason why he should be given leeway and that he shouldn't be bound by the orders of this court, the rules of the community, the laws of the state of Michigan, Your Honor. Speaking of those laws, Mr. Kelly has still yet to state any defense to his driving in the community, probably since 2017, without a license. The lease that he signed clearly states he is to be in compliance with the laws of the state, local ordinance, federal law. And Mr. Kelly is in violation of Michigan state law by driving without a license in the community. He's been living there since 2017, and I believe he acknowledged at the settlement conference on the 22nd of October that he hasn't had a license since 2017. So that on its own is sufficient grounds for this court to grant a judgment of possession. And I believe Your Honor even alluded to that at the last court date and still gave Mr. Kelly the courtesy of having an opportunity to appear for a bench trial and bring his witnesses. With respect to this alleged retaliation or retaliatory eviction, Your Honor, the statute is very clear on what constitutes retaliation, and Mr. Kelly has yet to cite anything in that statute that my client, that he has done that would bring about a claim of retaliation by my client. But even if he had, Judge, that is a rebuttable presumption. And my client would still have the ability to show that they have legitimate grounds to terminate Mr. Kelly's tenancy. Your Honor, at that settlement conference, it was discussed how Mr. Kelly's answer was deficient for a number of reasons. One of those things being that he in no way addressed the specific issues that were referenced in the termination of tenancy notice, that being the animal loose in the community, disturbing other residents, parking on the lawn, failure to maintain the home and site, verbally abusive towards management. He's addressed a few of those things today, Your Honor. My client would acknowledge today that certain issues with respect to violations relating to condition of the site were addressed. But as we discussed at length at the October 22nd hearing, Your Honor, with respect to the vehicle, it sat there for months after violations. And Mr. Kelly didn't do anything about it. My client had to ultimately have the vehicle towed. So there's a violation right there that there's clearly no defense to. With respect to the verbal abuse of management, Your Honor, how do you cure that? You can't go back and take the words back. I mean, it happened. So that's not really a curable thing. With respect to disturbing other residents, that's something that continues to happen.
That's not true. I mean, that's just a statement.
Mr. Kelly, I didn't interrupt you.
Oh, I'm sorry. I can't talk. I thought you were done. I'm sorry.
You will have an opportunity to respond. But Your Honor, we talked at length on October 22nd about how Mr. Kelly's answer was deficient because it didn't address those things. And in filing his motion, Your Honor, he still doesn't address those things. The only things that he brings up is this alleged audio recording that he thinks will prove retaliation. But that's not going to be sufficient. The statement that he's provided does not give any detail, which is the issue that was precisely stated at the hearing on the 22nd. And Mr. Kelly is still not following the rules and now expects the court to give him leeway again. The court has already done that by setting the matter for a bench trial on the 30th. Mr. Kelly's own motion, Your Honor, clearly states, I made the decision not to come to court because I didn't want to bring my daughter. He made a calculated decision based on the circumstances not to come to court. And he has not set forth anything in his motion that should change that outcome, respectfully, Your Honor. And so I have to ask that this court deny his motion and allow the judgment to stand.
Your Honor, I want to address the motion itself. She had brought in I meant to put that under the ex parte where I marked the money to go into escrow.
But there was no escrow filed.
No, there wasn't, but there was a box. Your Honor, when I was before you, it was, you know that I have money problems. I have a fixed income coming in every week, every month. And when that comes in, I can pay any arrearage. I mean, and that's what I was speaking to when I met the demands, when only in the money, I wasn't talking about here, but when I went before you, I've been going before you for the last 4 or 5 months before the just cause. And what I was saying was that, you know, when you said pay on this date and the court said we did, except the one time when I was $43 short, which she'll probably bring up. And regarding the settlement agreement, I was going through these. In fact, I was on the car on the lawn discussing it and speaking to you, Your Honor, when you discovered the warrant thing, and then I was taken out. And when I came back, we didn't discuss anymore. So, I mean, I don't know how I can address it better than that. We were addressing it and going down the list, but then I didn't, you know, I didn't get to, but, you know, it's kind of hard. I'm trying to follow her. You know, some of these things, she says that in my answer, I don't explain things. It's kind of general. Well, this stuff doesn't either. It just says that, you know, she's stating that the abuse and threatening of staff, I have yet to hear, what are you talking about? I mean, we can all throw out things out there, but what did I say? Who did I say it to? You know, what was it? Because I can remember that conversation and the incident because that coincides with the electrical cord. So, I mean, it's I mean, these are kind of vague too. I don't know how to defend them, but there is the reason there's a civil right, and I did put the letters wrong, but as far as the Michigan Department of Civil Rights, that I do have a case number or a complaint number, and that's for the very reason that I've been trying to explain to you about the differences in her, you know, her writing me up, or the landlord or the property manager writing me up and not writing the neighbor up for the exact same thing. I mean, that's listed in discrimination by the state of Michigan. I read it, and it uses an example like that. Like if you have a resident here or a tenant here that is late for their rent, and you go in and make a move on them, but across the street is the same exact thing. They're late on rent, but you don't there. That's a civil infraction from what I've read, or it's discrimination. And that's what's going on here. That's why I kind of brought in, you know, sent those pictures to you. I mean, and as far as the day I missed, that was a terrible week. It was my responsibility. I say that in my motion that I got cuffed and thrown in jail. But, you know, I get home and I'm on this website that I've never seen before. My daughter brings it in, and it's you, and it says contemptuous defendant goes out the back door. And gosh, the comments were brutal. I mean, brutal. It's not up anymore, but it was, and my daughter actually answered to some of it. So that week was just brutal. But I said that about my daughter because and the neighbor that drove me here, he's left, so I'm stranded again. But he will attest that we were ready to. He was my ride. He usually is, and his car's in the driveway right now. It broke down, and I did try to get other rides, but everybody's at work at that time of day. So what I meant in that was I did have my daughter. If I do get a ride, I got to take her. I wonder if
you said you had made a decision not to.
Well, only because I didn't know if it was allowed at the
No,
court.
no. You're telling me you had this and this is what you would have done. But your motion says you had made a decision because of your daughter not to come to court.
With
Can't
her.
have it both ways.
No, I know.
Mr.
I explained before that but I was gonna bring her, Your Honor. That's what that meant. But I said I don't want to make you mad again because I didn't know if minors were allowed in here. I mean, it explains that before that. I mean, she wants to, she's 13. She wanted to make a statement to you about it because it's kind of her house. But that's what I meant by it. I take her everywhere since she was born. I have no qualms bringing her, but I meant that because I tried to find rides. We couldn't find a ride with the neighbors. They were all at work. John's the only one that can give me one. Car still broke down in the driveway, Your Honor.
Your Honor, may I respond?
Go.
Please.
Keep going, Mr. Kelly, whatever you want to say. I mean,
I can tell you where it's going, and I'm not an
you
expert.
can't tell anything about it.
Okay, maybe you're right. I'm sorry. But this is very tough to just present it in a professional way and say it as I mean, but that's honest. I mean, I was trying to get a ride here, but that was the final decision. So I don't get a babysitter for her and go hitchhike down Michigan. I just said, since she's here, that was just meant that I made that decision after I couldn't find a ride. But I haven't skipped your court dates. I'm looking to save my house. I mean, and it's not necessarily,
Mr. Kelly,
it's not necessarily to stay there, Your Honor.
Mr. Kelly, I'm going to stop you because
Okay. May I say,
you just sat here, tried to tell me some story about that you were going to appear. I'm going right to what you filed with this court.
okay,
I have good cause for my failure to appear. I did not appear / answer because, I did not go to the court because I had an emergency hearing regarding my 13-year-old daughter the night before. Says nothing about you actually bringing her. Says nothing about her coming to the court as though you just represented to the court. You didn't come because of her. I'm done.
I don't have it by memory.
I'm so done.
Please, Your Honor, I just want to.
Mr. Kelly.
You're going to tow my house away with all my possessions? Not you.
Mr. Kelly, I'm going to follow the law. I've listened to you all day and you keep going back and forth in some of these things. But I'm ready to rule. I've listened to the plaintiff. I've listened to you.
Please give me a trial, Your Honor. Please.
Mr. Kelly, I gave a trial date for the parties to be here. It should be noted, although plaintiff didn't say much about it, plaintiff was here with all of their witnesses waiting for you to appear. Everybody interrupted their day.
I know.
They were here ready to go and you didn't appear. And quite frankly, from the court's perspective, the court doesn't hear from you for a good 9-10 days after the trial date. Don't hear anything about what happened, this, that, nothing.
Sorry, Your Honor.
No, you don't have to be sorry. I'm just saying, you're distorting what has transpired. Plaintiff was here, ready to go, ready to, I'm presuming, state with specificity, have testimony and evidence regarding every one of their allegations. You do not appear. Your notion that you've been following the direction of the court, not true. I had to beg you to get an answer into me. I finally got that to happen, told you to pay escrow, you didn't do it, and then still didn't comply with the escrow issue. You may have your reasons, but don't say you followed the direction of the court when you didn't, and you know you haven't.
I guess I
And
should,
then-
I tried my best.
You know
I'm
what,
sorry.
Mr. Kelly, I have listened to you all day.
Right.
Now is my turn. I do not want to be interrupted. So for the reasons, part of the reasons regarding your, as I've indicated, there are two prongs you have to satisfy. One is you had good cause for not appearing. You have by no means established that you had any good cause whatsoever from appearing on that date. Now, you make it sound regarding your arrest on the bench warrant as though somehow or another you were manhandled, put in jail, locked in a cell, way down. Let's be real about what happened. You got locked up because there was a valid bench warrant out of 14A4 District Court. My court, but handled by another judge. That judge, as I told you, happened to be here that day. We took you into custody. I spoke with her to make a determination as to what to do. And one thing you never said about it, ever, because you're just trying to create sympathy, is you were released that same day. Told what your trial date was, told everything, and you were released without having to post. In fact, when you came back, I arraigned you on the bench warrant and gave you the date to go appear for your driving while license suspended. So don't make it seem like somehow or another this evil judge all of a sudden locked you up on a driving while license suspended and just left you sitting in jail, and that because of that you could barely get yourself out of jail and then appear for trial. That's not what happened. Do not interrupt. And then you sit here with these meritorious defenses or whatever you're trying to claim are defenses. I agree with plaintiff. You have not established any of those defenses, particularly the one you keep trying to harp on, which is a retaliatory conviction. There's a predicate before you can even allege that. You've not even gotten there. Nothing you've alleged is even close. So you don't even have to go through a further analysis of it. You haven't started that type of action against the plaintiff. You've not stated it and haven't shown anything regarding that. The cold-hearted reality regarding the meritorious defenses is, and this is just the reality of how it works, plaintiff would have to just show one, and it could lead to your termination of your tenancy. When you place yourself in this position, you have to show me a meritorious defense to all of their claims. You failed to do that. I honestly don't believe that you've established even one, but you certainly have not established any defense whatsoever to any of these claims. I'm done. You just haven't established. And so for those reasons, your motion to set aside the default judgment is denied. The court specifically finding that good cause nor meritorious defense has been established. The judgment will stand, the writ of restitution will issue. Because the writ of restitution is issued and there hasn't been a written answer filed to the motion to remove the manufactured home and the time has passed, the court will also sign that order and grant that plaintiff's motion regarding that. I am done.
All my
Thank you.
stuff's in there, Your Honor. All my daughter's stuff, the neighbor's stuff. And my equity in the home. I want to say thank you that day. I did say thank you. It's on the record for you letting me go home that day I was caught. I was very grateful for it, so.
Your Honor, I believe I submitted proposed orders for both, an order denying
Yes.
attendance and a motion, and an order granting our motion.
And I have signed that order. I have signed the writ, and I have signed your order regarding the removal of home.
Hey, everybody. So a neat thing that I get to see is I get to see how many thumbs up and thumbs down there are. 30 minutes ago, when this was just starting, I had 3 thumbs down. Now it's down to 1 thumbs down. So there's been a couple of people change their minds during this one. And you would think during that long ass hearing, that'd be the worst one so far. I like how Rachel took care of that. I'm almost certain she was the one during the Haley trial, wasn't she? I'm almost certain she was. But she held her own, and like I said, I can see a young Rachel McDuffie in her. She's got some spark to her, so it'll be neat to see where she goes. Oh, there I go with a second thumbs down. Thanks a lot. We're knocking them out tonight. We got Judge Fleischer coming up. There we go. That's the funniest thing. The thumbs up and thumbs down. It knocked out 4 more thumbs up, so everyone gets to do whatever they're going to do. There we go. A bunch more. Yep. Fozzie says, yep. No, it's funny that every day normally during the first 10 minutes I get a thumbs down, and so I call that my super fan. I figured if they put in the effort every day to come to my show just to give me a thumbs down, I appreciate it. Oh, there's number 3. So we got it back. All right, we're going to jump over to Judge Fleischer. That way we can get a lot more thumbs up. I'm not sure what it means, but they seem like they're important. So let's go to Judge Fleischer. And then we're going to call it a night. This one's 12 minutes long, so this one will take us up to about 9:50 Eastern time. 7:50 for Julie.
Ready?
Yes, Judge.
Come on up.
Judge, I'm approaching on a Tammy Johnson case. She is in custody at the moment. Did you get that, Judge? Tammy Johnson.
Yes.
So her bond is set currently at $1,001. She doesn't have any ability to make bond. From kind of going through the procedural background of the case, it sounds like she'd gotten a GLB bond originally about a year ago.
Wow, she's been gone that long.
Well, did not come to a setting and have a chance to meet you, Judge. And so, because had she have gotten an admonishment from you, she'd have certainly attended.
Good try.
Can
you bring up Ms. Johnson, please?
She does not have any criminal history, and this is kind of a DWI. I've chatted with them briefly about it, but the allegation is that the police found her asleep in a parked vehicle at a gas station, and with the car in park, but they say on.
I've done the research. We had this issue not a week ago, and I'm telling you.
Well, it's sufficient from a legal sufficiency standpoint, it can stand, but what do jurors think?
I combed through like 20 cases. Give me a second. We did the diligence as far as that argument is concerned. My only concern now is that she's been gone for how long, but for this, she would still be wherever she is, right?
Well, she's got a kind of difficult financial situation. She got family, but she's talked to her family and doesn't have the ability to make even what would be roughly paying $150 to get it. And, but she's 43 with no criminal history. She's got 2 children that she successfully raised to their young adults.
Come up, ma'am. You were Tammy Johnson. How's jail? How's jail?
Different, Judge.
Why do we have jails?
Criminals off the street, I guess.
Yeah, that's a good reason for sure. Why else?
Judge, she knows
to make sure you come back. And when you don't, the sentences get longer, the bars get colder. Just, that when you fail to appear, your bond's at $1,000 right now. So all that needs is $100 and you're out. $125, you're out. You now know that you have no one to pony up that kind of money, no one to pony up that kind of money to get you out. Mr. Garris is asking me to let you out. The only reason you're here now is because you got busted. Otherwise, you'd still be out who knows where. Why would we let you out? You tell me.
she wants to move forward and deal appropriately with the case. And the state has given me quite a bit in the way of discovery to review. And as with any type of blood case, there's probably going to be more that we venture out to seek, but it'd be obviously sometime, we talked about it, the idea that these can take 6 months, 7 months to even get ready to see if it's a viable case for trial.
Therein lies the problem where, ma'am, you sit now in custody until the case is either pled, you're in trial, or somehow gets disposed of. That could take 6 months. Where have you been?
I'm trying to get my life together.
Judge, she's worked for a long time as a waitress and is living, and she's living kind of difficult situation at the moment. So it's experienced bouts of homelessness but now has a more stable situation. She has the ability to get to court and will be here. That's the representation we're making to the court. And I think we can do short resets if you'd like.
You know, Mr. Garris, I never want to leave someone in custody, but one of my primary concerns also is not putting someone out on the street. And I'm telling you now, I'm willing to give you another chance, but I'm not gonna put you out on the street if you ain't got nowhere else to go.
She does now. She's living in she has a motel that she's living in now, kind of temporary housing.
Yes, it's permanent. It's been for a while.
I don't believe that for a second. Who do you have in your life that's willing to take you in?
I've got that information, Jeff.
Before I had no one, but now I do.
But he just doesn't financially have the ability to.
The only thing that's changed between now and then is you got arrested. Ms. Johnson, the last thing I want is you to be put on the street where you look like you're going to start using again, because I don't want you to use. If I were to drug test you now, what are you going to test positive for?
Discussion about that.
Here's the drug. I'm going to drug test you like crazy. And if I find that you're using, then I'm going to keep you. And I'm not going to play this game. You can't even look at me in the eye.
Drugs aren't a problem.
Don't. Okay. At this point, Judge, I'm going to admonish my.
It's okay. That's all right. So where do you have to go?
Judge, let me answer all the questions. She lives in a motel, stable situation, can make her way back to court. And
that was the smartest thing that lawyer could ever say is, Judge, let me answer all the questions.
You can do short resets and we'll be here. And that's the understanding that we've talked about, and I think would be appropriate at this time would be to give her a chance to come in, and obviously we'll comport with all the requirements that this court installs. And if we have to do testing, we'll do that. And
let me make something perfectly clear to you, Ms. Johnson. I don't like it when people plead guilty just to plead guilty to get out. I'm not down with that. And we're not going to play that game here. So if I let you out, I expect several things from you. Number one, that you're not going to endanger my public. That's the first and foremost. Number two, that you're not using alcohol and or illegal drugs. And I'm telling you, I'm going to test you like crazy. If you can't stop on your own, then we will do it my way. And I promise you're not going to like the way that I do it. Do you understand?
Sure.
Number three, if you don't have a license and liability insurance, you are not allowed to drive. Do you have a Texas driver license? Then you will be signing with me today an affidavit. This is a promise you're making to me that you're not going to drive. And I don't care if Jesus needs to ride to church, you get into a car and drive. I can have a contempt hearing and you'll be facing 6 months every time you drive. Do you understand? Do you want me to give you a PR bond? Can you stop using?
Yes, sir.
I'm going to let you out and I'm going to have you come back here on Tuesday. And I want you to come back and take a test on me on Tuesday. And I want to know for sure. You got to understand, you've played Monopoly, right? What do you get in Monopoly to get out of jail? What do you get? You get a get out of jail free card, right? This is the only one you're going to get. You're not going to get another one. Do you understand? So I will let you out now. but I expect you to comport and comply with conditions. And that's it. I'm not asking for much. I'm just asking you to be sober and come back to court and stay in touch with counsel. That's all.
Thank you, Judge.
Of course. Now, we will set her for Tuesday. She got to come back here Tuesday. You don't come back, a warrant will issue, and we're going to just play the 6-month waiting game while you're there. Because I'm telling you, I don't accept pleas just to get out of jail. All right.
Thank you, Judge.
Thank you.
All right, thank you.
Thank you.
She can't go yet, though. We need her to sign conditions with, yeah.
Judge, can you go over those conditions again?
No drugs, no alcohol, random urinalysis. She's going to come back on Tuesday to take a drug alcohol test, and no driving. And show up to court. And I'll reinstate it, that we don't have to work on the bond. Sure.
What's the last name again?
Top of 26. Someone just walked in.
Maybe like 20-30 minutes ago. And also James is trying to zoom on. He said no zoom on. Okay. It's probably just.
Question about the UA that's left,
Okay, but
Well, I can always tell when I get lazy on editing. I wouldn't have left all that on there at the end. So I'm going to throw up one little quick clip right there at the end. And hey, Julie got greened. Congratulations, Julie. Vicky, thank you so much, Vicky. Thank you. That means the world to us. I really do appreciate it. Hey, it's Elle. How are you doing today, Melissa? Thank you, everybody. Thank you for such a lively comment section, and thank you, everybody, for sticking it out this long. I'm gonna throw on a short little video. We played it the other day, but it's worth playing again to run us out. It's a little short one, so nobody will catch it. All right, you guys have a great night, and we will see you tomorrow.
all right, guys, we're gonna let you go. Thanks for hanging out with us. And Swede, we love you too. Drunken Smurf, Nan, ATX, Marciano, Galkey, Stock Vendors, Chrissy, Bystander, Catch It, Mr. No, the guy who knocked. We love all you guys. Thanks for hanging out with us. Say bye to Linus.
I'll be back home. Yeah, there you go.
See you guys.
Oh, I know, right?
See the video.
Oh, I feel so great. Let me just get on your level.
Bye, Michael. We're gonna go out to eat.
Today?
Bye, Michael. I'm stealing your wife. Good night.
All right, bye, guys. We're gonna let you go. Thanks for hanging out.